Good morning, everybody. My name is Nigel Nordone. I'm the head of tax at Qdos. And in the first of our technical series, I'm going to be talking to you about one of the key status tests when it comes to determining somebody's IR35 status or employment status. And that is the test of personal service, which is more commonly known as the substitution test. If you have any questions throughout the session, if you want to submit them via the Q&A panel, and then hopefully at the end of this session, I will be able to answer them for you. So in this session, we will be covering what is the right of substitution and why it matters, HMRC's CEST tools view of substitution, and substitution in practice. So when it comes to determining someone's status, the right of substitution is considered one of the key tests and is often pivotal in any status decisions. But it's only one of the tests that HMRC consider when looking at somebody's employment status. And these tests that we use and that HMRC use stem from a 1968 tax case called Ready Mix Concrete versus the Minister of Pensions. And in that case, the judge who was presiding set out three key status tests. And what the Judge McKenna said was, if these three tests are present in a contract, then it is a contract of service, in other words, one of employment. And one of those key status tests is personal service, which is more commonly known as the right of substitution. Other tests that that need to be considered are control and mutuality of obligations, but obviously today's webinar is purely concentrating on the right of substitution. When HMRC decide that they're going to investigate a contractor in respect of IR35, they will look at the typical, if you like, engagement chain. And usually in most cases, you'll have the worker, which is the director of the limited company, their personal service company, obviously the limited company itself, more often than not an agency, and the client that the limited company contractor has a contract with. And what HMRC try to do as part of an investigation is they try to create what's known as a hypothetical contract. And essentially what that means is HMRC say, well, when we look at this chain, this engagement chain, and you have the end client, the agency, the personal service company, limited company, and the worker, hypothetically, if we stripped out the personal service company and the agency, and the director of the company, the worker, was working directly to the end client, does the end client treat them in the same way as they treat their employees? Now, if HMRC, after carrying out their investigations, can show that that is the case, they have created what's known as a hypothetical contract, and therefore they have created what's known as the contract of service of employment. And essentially, that's all HMRC tried to do when they carry out an investigation. They tried to see whether, if the contractor was working directly to the end client with no limited company and no agency in between, would they be treated in the same way as an employee? And if the answer to that question after the investigation is completed is yes, then the contractor will be caught by the IR35 legislation. So what is the right of substitution? It is the ability of a business to deliver services to the client using the resources it sees fit, as it sees fit. A genuine business should be able to provide a suitably skilled and qualified worker of their own choosing to deliver the services. It's important to remind at this stage that the contract that the agency has with the limited company and the client has with the limited company is between the personal service company, i.e. the limited company, and the client or the supplier. It is not with the individual worker. And so there shouldn't be an outright requirement for the worker's personal service. In other words, when a business engages the services of a limited company contractor, it's the limited company that they should be engaging and not the individual person. If the client asks for a certain contractor personally to provide the services and will not accept the services to be delivered by another qualified individual, then this essentially would diminish the purpose of the client engaged in a limited company from the start. And what HMRC would argue, if they had carried out an investigation, is because the client has asked for that worker personally, their personal service is required, and therefore they would not have a genuine right to substitute a worker in their place. So you can see why it's very important for clients and contractors to understand that when they enter into a contract for work, it's done on a business-to-business relationship. So it should be one business engaged in the services of another. As I touched on earlier, the right of substitution and the key status test were set out in the ready-mix concrete case versus the Minister of Pensions back in 1968, approximately 32 years before IR35 was introduced. The right of substitution has been considered one of the strongest tests of self-employment since the case of Chaplin versus Australian Mutual Provident, which from 1978, if anyone's interested, which held that the power of unlimited delegation is almost conclusive against a contract being a contract of service, in other words, one of employment. And this judgment was upheld in the case of Echo and Express Publications versus Tanton in 1999. In the ready-mix concrete case, what Judge McKenna stated was his judgment makes clear that the freedom to do a job either by one's own hands or another's is inconsistent with the contract of service. Essentially, what Judge McKenna said was, if your personal service isn't required, if you can send someone in your place who's equally skilled and qualified to carry out the work, then it has to be a contract for services. In other words, you have to be self-employed, because I'm an employee of Qdos, and when Qdos gave me the job that I have today, it's my personal service that they require. If I wake up on a Monday morning and feel not in the mood to go to work, the only thing I can do is either take a day sick or take a day's leave. I can't send someone in my place to do my job because Qdos expects me to come in and perform the work. If someone is genuinely self-employed and it's a business-to-business relationship, providing the person that business sends is equally skilled and qualified and capable of carrying out the work that you require them to do, then their personal service isn't required, and therefore, based on case law, the ready-mix concrete case and numerous others, they must be classed as genuinely self-employed. There are other cases that support the fact that substitution is one of the key status tests, and one of those is UseTech Limited versus Young, reinforced that substitution had to be genuine in reality, and substitution was a key factor in the Pimlico Plumbers case as well. So, case law has made clear that it is the right to provide a substitute which is important, not the logistical ability of the contractor, i.e. whether they have someone waiting in the wings or not. And this is echoed in HMRC's own employment status manual, where it states that it is the right of substitution that is important. The fact that substitution has not actually occurred during a contract is not necessarily relevant. Workers with such a right are, of course, entirely free to carry out the work themselves if they wish. The right must genuinely exist and not just be a clause in a contract which wouldn't ever be allowed should the circumstance actually arrive. And the right mustn't be unduly fettered. And what this means is that there mustn't be any unreasonable restrictions imposed. So case law has established that it's the right to substitution that is important, not whether a substitution has actually taken place or not. But that right must be genuine and it must not be unduly fettered. So for substitution to be considered genuine, the limited company must remain liable for all costs associated with the substitute. When substitution occurs, the limited company must be paid as per usual by the client, and the company will pay the substitute directly. The limited company that is requiring the use of a substitute and is going to replace the worker who is currently servicing the contract with a substitute must choose the substitute, and they must pay the substitute directly for it to be a genuine substitution. Substitution is about the limited company providing any suitably skilled and qualified worker on behalf of their business, and so the limited company should remain responsible for any substitute in the services provided. The right must not just be a clause in a contract, the right must actually exist in practice. And with this, we're talking theoretically. Many contractors get confused over how it would be possible to send a substitute in their place if there's no other employees within the company besides themselves. However, it's worth noting that a substitute does not necessarily have to be an employee of the limited company. A substitute can be outsourced by the limited company, but it does not mean they have to have somebody lined up with the task. This is where the importance of the right to substitute comes in more so than logistical ability. So even if the question we get asked a lot is, we say, well, hang on a second, we're engaged in the services of a limited company. We know they are a one-person limited company. So therefore, we know they haven't got any other employees to send. But as I said, it's the right of substitution that is important. And just because the limited company is just one person, one contractor, it doesn't mean that right is genuine, because ultimately the limited company contractor can send a substitute of their choosing, providing that substitute is equally skilled and qualified. So it doesn't have to come from their own limited company. It could come from another limited company or somebody else that they've worked with in the past that they know. But as long as the person has the same level of skills and ability, then they can provide them as a substitute. They don't have to be an employee of the limited company that needs to use the service of the substitute. So what is unduly fettered? Really, we're talking about unreasonable rejections of a substitute and undue restrictions on the right to substitute. Some examples of this might be the requirement to only use substitutes from pre-approved pool of contractors. Essentially, as I've already touched on, who the substitute is should be entirely down to the discretion of the limited company contractor that needs to utilise the services of the substitute. There shouldn't be any diktat from the engager or from the client as to who the substitute should be. One of the other things HMRC classes something unduly fettered would be if there's a substitution clause within the contract that has a phrase in it such as the substitute will only be accepted at the end client's discretion. Now, the word discretion doesn't seem that important, but what it means is it gives the end client the room, if you like, to say, well, do you know what? We'll put in these sort of barriers to prevent a substitute being used because it's at our discretion. So we can decide what we will and won't accept as a substitute. Another reason that HMRC would class a substitution clause as unduly fettered would be if you needed to send a substitute and the client that you were sending the substitute to said, well, that's fine, but we've got like a 10-day onboarding process to bring a new contractor in. You know, we don't mind that you're picking the substitute and we will willingly accept the substitute, but it will take us 10 days to onboard them. HMRC would say that was unduly fettered, because their argument is that what would happen if the contractor who was working on a contract that was, you know, time limited, only had a few weeks to run, and it was massively important that that contractor could, you know, or someone of that same level of skill and abilities could carry on delivering the services in order to meet a really tight deadline. HMRC would say, what happens if that contractor went home, slipped on some ice and injured themselves, put them out of action for 2 or 3 weeks, but you had a 10-day onboarding process? There was no way a new contractor could be brought into place in time to fulfill the parameters of the contract. So they would say it has to be a realistic substitution. The chance to substitute has to be realistic, and it has to be able to take place within, we sort of say 24 to 48 hours to bring a substitute in is ideal. Restrictive work in the contractual clauses would go beyond skills, qualification, experiences, or security clearance. As I said, discretion, reasonable, anything that gives the end client a little bit of discretion over whether they can accept someone as a substitute. It should really always be that a substitute would only be rejected because they weren't suitably skilled and qualified. Another consideration when it comes to limited company contract is the use of helpers. The use of a helper can help demonstrate a lack of personal service. However, it isn't as robust as using a full substitution, as it doesn't entirely demonstrate complete lack of personal service from the initial worker. So what's the difference between a substitute and a helper? It largely comes down to the level of involvement in the service provision. A substitute will fully replace the worker in the delivery of the services in full or in part, such as if the principal contractor had long-term illness or a holiday. Whilst in an instance of a helper, they can be brought in to do usually small tasks such as documentation or in some cases design work, whilst the principal contractor still delivers the services to the client. In both cases, the contract remains with the original limited company. When it comes to helpers, it may well be that as a business, the contractor is already using someone to do their paperwork, to do their bookwork, whatever it might be. And as the engager, they may not even know that someone is using a helper. So obviously it would still be an argument you would use in an investigation with HMRC, but ultimately actually it's the right to substitute, which carries more weight than the use of a helper. So we now come to HMRC's CEST tool and how it deals with substitution. Now, CEST is HMRC's status checker. It's the check of employment status tool. The CEST or check of employment status tool is HMRC's digital tool for engagers to determine the IR35 status of their contractor workers. And has always been in contentions in terms of determining IR35 status. One of the key determinants in deciding someone's status, one of the three key tests is a test called Mutuality of Obligations. And without obviously going in depth as to what that means, that test is actually ignored, or was previously ignored, in HMRC's CEST tool. So whilst Judge McKenna in the Ready Mix Concrete set out three key factors that have to be in place for someone to be classed as an employee, HMRC pretty much ignored one of the key tests. So there was lots of issues around CEST and the fact that it wasn't robust and it didn't give a genuine view of whether someone would be considered self-employed or not. As I said, when it was first released, it would determine IR35 status of the worker by answering only a few questions. For example, if a worker had indicated they could provide a substitute, which the end client would not be able to reject, the likelihood is that an outside of IR35 option would be provided. However, the tool has now been updated, and it was late 2019 when that happened. And it now seems that even where there does appear to be a genuine right of substitution, further questions will still be asked concerning the working practice of the engagement, starting to align with HMRC's own guidance and case law, but there's still a lot of work to be done. Essentially, HMRC's CEST tool, whilst has been improved, and I use that in the loosest sense of the word, it still falls well short of what you would want and need to basically to establish one's status. I mean, it ignores IR35 key tests, as I touched on about mutuality of obligation. It relies heavily on substitution. It's a very limited question set. A lot of court cases, a lot of tribunal cases, it doesn't even get used. And there's even instances of HMRC arguing that the results of a CEST test shouldn't be counted on because it wasn't reliable. It's their own tool and that they don't think it's reliable. It doesn't allow for the finer details around working practices, etc. And it is pretty much irrelevant in an IR35 inquiry, because HMRC will say they will stand by the result of a CEST test, providing you've answered the questions correctly. Now, HMRC have a different view as to how questions should be answered compared to most other people. So, it's a bit subjective, and it's not something that we recommend contractors to use. And as you can see, 86% of contractors lack trust in the tool. So what does the CEST tool say about substitution? If the work has already started, you will be first asked if the right of substitution has ever been exercised. Now, this is relatively straightforward, but the tool doesn't ask any further questions if your answer is yes, but you didn't accept them, demonstrating the lack of detail given by using the checklist approach. The key question on CEST, however, asks whether the engager has the right to reject a substitute with a binary yes or no answer, rather than if the worker has the right to provide one. A crucial difference is in most cases, an engager will always consider having the right to reject, because even if there is a substitution clause, ultimately the engager does have the right to reject, because they can reject a substitute worker if that worker wasn't suitably skilled and qualified. Because ultimately, if you're looking for an engineer and the contractor you're engaged with, I'm going to send you a substitute who's a painter and decorator, there's no way on earth you would accept that person because they wouldn't be suitably qualified and skilled enough to carry out the work you wanted to do. In the explanatory notes, it states, this can include rejecting the substitute even if they're equally qualified and meet your interviewing, vetting and security clearance procedures. However, in the CES section of the Employment Status Manual, it states, where the hirer can only reject a substitute upon grounds that they are not qualified to perform the work, this would fall within the no category for CES, providing it would be practical and plausible for the worker to send a substitute. The Employment Status Manual provides guidance for HMRC staff and is not linked to or from CES, but this clarification would have a significant impact on the user's interpretation and subsequent answer to one of the most important and pivotal questions on the tool. The problem with CES is like I said, it lacks depth, it lacks nuance, it ignores some of the key status tests, and the questions, as with any questions you get from HMRC in regarding status, are kind of slanted in HMRC's favour, because ultimately the aim of any HMRC investigation, contrary to whatever HMRC may say, is to find somebody within IR35 to say that they're operating under a contract of service, one of employment. HMRC aren't in the business of trying to prove that someone is genuinely self-employed, because that's not what their remit is. Their remit is to bring in more tax. Therefore, any tools that they have to and any questions they ask in establishing status are heavily weighted towards their side of the argument rather than the contractors. So depending on your answers to the previous question, you may be asked if the worker would have to pay the substitute. Here, HMRC are looking to establish if the right is genuine, i.e. is the limited company sending another worker from the company to provide the services, or is the end user simply engaging with another business? I mean, ultimately, as I said, for a substitution to be genuine, the limited company, the personal service company contractor should decide who the substitute should be, and they should continue, and they should pay the substitute. So the client should continue to pay the original limited company, and the limited company then should pay the worker that's coming in as a substitute. Finally, again, depending on previous answers, you may be asked if the worker has engaged a helper. This questionnaire is a yes or no response, and whether you answer yes or no, there are no further questions asked in regard to this point. CES seems to put less weight on this question than it does those on the previous questions. I mean, ultimately, if you say yes, I've engaged the services of a helper, really, there should be further questions, as in, what type of service do, how much of the work did they do, etc., etc. But HMRC, like I said, they ask one question and then they move on. So substitution in practice. In the case of Hall v. Lorimer in 1993, the judge said, in order to decide whether a person carries on business on his own account, it is necessary to consider many different aspects of that person's work activity. This is not a mechanical exercise of running through items on a checklist to see whether they are present in or absent from a given situation. The object of the exercise is to paint a picture from the accumulation of detail. When it comes to deciding IR35 status or employment status, there are three key aspects, like the three key status tests. You have the contract, you have the contractor's view of their day-to-day working practices, and you have the engager's view of the day-to-day working practices. They all match up in the correct way, then hopefully everything will be fine and the contractor will be seen to be outside of IR35. You can have the world's best contract written. It can be the most perfect contract in the world. It can have all the correct clauses in respect of substitution, in respect of control, in respect of mutuality, financial, all the things you want in a contract to prove that someone is outside of IR35. But if it's not a true reflection of the actual day-to-day working practices, the contract isn't worth the paper it's written on. The other thing to remember, it's important for engagers who bring in limited companies to carry out work to remember that the lack of substitution does not necessarily mean an inside of IR35 result. There are three key status tests. So even all you have to show is that one of those key status tests isn't present for someone to be classed as self-employed, because it's only if all three are present that someone is deemed to be an employee. Many businesses, in particular in the public sector, but in the private sector as well, have been blanketing inside IR35 or banning the use of contractors on the basis of the substitution test. largely part of the CES tool, which used to issue an inside determination following having substitution questions when it was first introduced. But as mentioned at the start, IR35 is determined looking at the working practices of the contract. And as the judge in Hall v. Lorimer case stated, the object of the exercise is to paint a picture of the accumulation of detail. In other words, you have to look at the whole picture. You have to consider the working practices of the contractor, the contractor's view of the working practices, the engager's view of the working practices. You can't just look at one small part in isolation to determine someone's status. It just doesn't work like that. As in the case with a lot of IR35 and its reform, there are often ways in which businesses try to force elements to try and achieve certain results. From contractual clauses which have no bearing in reality to unnecessary forcing of substitution. Any use of the substitution clause should be born out of a genuine need, and necessarily outsourcing admin tasks which would be a helper rather than a substitute, or merely swapping substitution days with another contractor within the same client could be seen as a contrived arrangement. HMRC will deem any contrived arrangements as deliberate non-compliance, which could put you at risk of penalties. Like I said, the right to substitution must be genuine. And you'll find over the course of these webinars that this is a common principle to apply to your IR35 and compliance. Contractual clauses must be a true reflection of reality. As I touched on just a minute or two ago, you know, the best contract in the world is pointless if it's not a true reflection of the day-to-day working practices of the contractor. And when a contractor uses a substitute, it must be because of a genuine business need, not just, well, we need to put a substitute in place because that way we can then tick a box for HMRC. HMRC have stated that they will not stand by results achieved through contrived arrangements designed to get a particular outcome from the service. This will be treated as evidence of deliberate non-compliance, which can attract higher associated penalties. So what can you do now? What actions can you take now? End users, clients should identify workers where personal service is required and assess why that is. Why are they being engaged by limited companies? And is this the most appropriate action or appropriate way to do it? Reassess your substitution policies and document those decisions. Many businesses seem to be afraid to allow substitution, but it's worth remembering that just because you allow substitution doesn't mean you're suddenly going to end up with hundreds of contractors all substituting. As mentioned on the previous slide, any substitution must be of a genuine need, and in the vast majority of cases, the need never arises. Ultimately, you have to remember it's the right to substitute. If this contractor, for whatever reason, was unable to attend to carry out the services for a few days or a week or a month, whatever it might be, but they could supply someone of equal skill, equal ability, equal knowledge, so that the contract would carry on, the services would carry on, would you be willing to accept that substitute? And I would expect in most cases, if someone could put someone in who is equal skills and ability, and there would be no disruption to your business, why would you not do that? Thirdly, make sure you have a clear substitution policy outline for your contractor hires and ensure this is mirrored in contractual agreements throughout the supply chain. HMRC have used restrictive substitution clauses elsewhere in the supply chain in order to refute a right of substitution in the recent past. Qdos can help establish and write such policies where needed. If we think back to one of the earlier slides, the hypothetical contract, where you had the worker, the limited company contractor, and their limited company, and then the agency. Normally what happens is the limited company has a contract with the agency, and then the agency has a contract with the end client. And more often than not, the terms and conditions in both those contracts don't match. They're different. And the limited company contractor has no knowledge of what's in the contract between the agency and the client has no knowledge of what's in the contract between the agency and the limited company. So what we're trying to say is, you need to get, wherever possible, align those contracts so that the terms and conditions match, and then that each of those contracts is a genuine reflection of the day-to-day working practices of that particular contract, that particularly limited company. Finally, make sure your stakeholders understand that the substitution test, as well as your company policies, hiring managers will be the first port of call for a contractor looking to substitute. And if using status review, we're usually with the person approving determinations. So it's vital they have an understanding ahead of April 2021. Thank you for listening. This is the first in a 4-part series. This afternoon you can join me talk about overseas arrangements, and tomorrow we'll be covering contracted out services and the use of statement of works to engage contractors. So feel free to join me for more then. Recording this presentation will be sent out at the end of the week. And if you have any questions on substitution, please feel free to ask for the Q&A panel. And I can already see that there's a few questions have come in. So I'll have a look at those now. So the first question is from Simon. One question I'm looking to answer from this session is whether substitution is enacted and evidence a contract is outside of IR35 and beyond challenge in law or practice. I appreciate that your answer may be nuanced. Yeah, I mean, essentially, as I stated at the beginning of the presentation, there are 3 key status tests: personal service, which is the right of substitution, control, and mutuality of obligation. If all 3 are present, it's a contract of employment. I'm an employee of Qdos, so my personal service is required, I'm controlled, and mutuality obligation exists. All 3 are present in my contract because I'm an employee. So conversely then, if one of those key status tests is missing, you can't be an employee, you have to be self-employed. So if you've enacted a substitution, then your contract would be seen as one of employment, self-employment, sorry. The only caveat to that, and I say it's only a small caveat, is that HMRC still, just because you say we have substitution, you show them evidence of substitution, it doesn't necessarily mean HMRC would say, thanks very much, we're closing this inquiry down. Because HMRC have a tendency to still look for more information. But ultimately, if you're a client of mine, I was representing you and you'd sent a substitute, then I would argue that IR35 doesn't exist. And I would expect HMRC to accept that argument. Can you still write in the, can you still write in the contractor personnel name into the contract, or could they be deemed to create a hypothetical contract? Ideally, what you want to do is look at this as a business-to-business relationship. So if you're engaged in the services of Widget Limited, just to pick a name out of the air, then ideally the contract should state Widget Limited, but you could then refer to a representative of Widget Limited being the name of the contractor, or add then in or a substitute where possible. Do you need to have an end client's approval for the substitute? How does that factor towards the validity of the right substitution? Yes, ultimately the contract will have, if presupposing you've got a contract that has a substitution clause that says the substitute will only be rejected on the grounds of lack of skill or knowledge or ability, then the ultimate decision as to whether a substitute will be accepted is down to the end client. They're the person who says, yes, we will accept substitute, or no, we won't. So if they say no, then the right substitution doesn't exist. And then you then would have to look at the other 2 key status tests. How is substitution affected by client vetting requirements? Again, as I touched on earlier, if the onboarding process for a business to engage a service as a contractor, whether that's the original contractor or the substitute worker, if it takes more than sort of 24 to 48 hours, then HMRC would argue that it was unduly fettered, and that it's not a realistic clause and not likely to ever be allowed to happen. But most clients will want to vet a substitute worker or any worker in the first instance to see if the skills and qualifications they've got, they do actually have those. And then there's some instances, could be security or other tests. So yeah, I mean, vetting isn't an issue. It's just how long it takes can be a cause of concern in some instances. When a limited company provides a substitute that isn't an employee of their company and they use someone is employed by a different limited company, isn't that subcontractor? How are these different? No. So if you send someone in your place to carry out the work, then that's a substitute. And if it comes from another limited company, that's fine. That's not a problem. Ultimately, providing the client is happy to accept the substitute, it doesn't really matter where you get them from. Subcontracting is more around where you're, as a limited company, you're given X amount of work. You pass part of that work on to other people, to do the work either alongside you or for you. But ultimately, what a substitution does, it takes the place of the contractor of the limited company that was carrying out the contract in the first place. If all the contract clause allow for substitution, but clients still refuse to accept a qualified substitute, does this not fail the mutuality test? Hence, that's IR35. So I send a substitute, client refuses to accept, hence the limited company is not able to work and get paid in spite of providing a suitable resource. Yeah, I mean, ultimately, if you said we need to send a substitute for whatever reason, and the client said, well, we're not going to accept the substitute, and you were then no longer able to carry on the work, you would have to assume then the client would probably terminate the contract. So yes, then you would then put the argument forward to HMRC that mutuality doesn't exist. But that would be in the instance where, for whatever reason, you were unable to carry on providing the services. A lot of times, if a substitute is needed, then some clients will say, well, okay, we know you can't send someone because we won't accept a substitute, but we're willing to allow you time to do whatever it is you need to do. But yes, if you sent a substitute and the client rejected it, and that meant you could no longer service the contract and they terminated the contract, then we would be arguing on your behalf, if we were representing you, that yes, mutuality test has been failed as well. Can the client interview the candidate or vet them, for example, in a bank who have security checks? Well, first and foremost, we would hope that the client would refer to it as an interview. It'd be more like a role or contract discussion. But yeah, ultimately, if you're engaged in the service of a contract, I come back to the very flippant example I gave earlier. If you're looking to engage service an engineer, and somebody turns up who's a painter and decorator, you're clearly going to say, no, we're not going to have that person, because you need to know that whoever you're engaging can deliver the services you want them to deliver to the standard that you want. So yes, the clients can vet, if you like, contractors, but what we would say is you have to be careful around your wording. You don't want to refer to it as an interview, because interview is what potential employees have and go through. Would formal partnerships agreements between limited companies be valid of extending capability to provide substitutes? Yeah, I mean, ultimately, if you're working, and I've got a working relationship with other businesses, and you could, and that whoever you want to use has got the same level of skill set you have, wherever you get the substitute from, providing it's a substitute that's acceptable to the end client and that is skilled enough to do the work, then that's fine. There's no rules to say that you have to source a substitute from within your own business or from wherever. You can basically source a substitute from wherever you like, providing that the end client is willing to accept them. What if the security process clearance for the substitute would take more than 24 to 48 hours, e.g. if the criminal record check was required? Again, it's we say 24, 48 hours, 3 days. That's what we say. We say, because it's an easy argument to have with HMRC. But ultimately, if you said to a client, I want to send a substitute, and they said, yes, we'll accept the substitute, but it took 72 hours to onboard them, the bottom line is that right exists because the client said, we'll accept it. HMRC say, a lengthy onboarding process, induction process, if you like, whatever you want to call it, it would make it unduly fettered. But, I would, as someone who's dealt with HMRC inquiries for many years, it'd still be an argument I'd be putting to them, because I'd say, well, the right exists. It's a simple fact. So there is no set time limit. No, there's nothing to say that 1 day is fine, 3 days is bad, 10 days is bad. But obviously, the faster you can bring a substitute in, then the stronger it makes your argument. Public sector clients have onboarding requirements, and it seems reasonable to expect onboarding. This would not prevent the substitute starting even 2 weeks later. So why would this be classed as not a valid substitute? I would class it as a valid substitute. All I would say is that HMRC would class it as unduly fettered. And basically for the reasons that I touched on earlier, that what happens if the contract was time limited, had a week, 2 weeks to go, and you needed to bring a substitute in to service the last 2 weeks of a contract. HMRC would say, well, if it takes 2 weeks to onboard them, the contract's gone. It's unfeasible. Again, as I've touched on, any substitution that took place, whether it took a day or 2 weeks for it to happen, I would still be arguing as a valid right of substitution. But obviously, it's persuading HMRC is the harder part of that argument. Most of our contractors can substitute, but the client has the right to reject substitute if the replacement does not have the right skills. Not unreasonable. Our substitution clause does confirm that the permission to substitute will not be unreasonably withheld. Yeah, I mean, essentially, providing the reason for objection is limited to the skilled, qualified, experience, then that's fine. There's no problem with that substitution clause at all. The HMRC employment manual states that a hirer cannot answer yes to accepting a substitute if it's not feasible or plausible to accept one. And this includes criteria like timeframes. However, I think most hirers would say that there will be times in terms of a contract where it is practical and plausible to accept a substitute and times when it is not. What would your advice be to a hirer faced with this problem? Essentially, the end client, the hirer, the decision to accept a substitute is entirely theirs. If they want to accept a substitute, they can. If they don't have to. It's as simple as that. And we, as touched on in the presentation, there are 3 key status tests. Personal service substitution is just one of those key status tests. So if you're engaging a subcontractor or a contractor, sorry, or you're the contractor being engaged and substitution isn't something that's feasible, you've still got 2 of the key status tests to argue, and you only need to say one of those isn't present for you to be classed as for you or the contractor to be classed as self-employed. So even though substitution is important, it is still only one of the 3 tests. So if you say we wouldn't let a contractor substitute, then look at the next 2 tests and see if there's an argument to be had there. Still on practical plausible, how does 24-48-hour ability to substitute stack against the need to be security cleared, which might take 5 days? Again, 5-10 days. As I said, HMRC class substitutions that take a longer period of time as unduly fettered. That's just HMRC's fallback position. Doesn't mean they're right. We would always argue, if a substitution has taken place, that it's taken place, the right is genuine, it exists. And, the flip side is that if HMRC say, well, what happens if it didn't, if you need someone immediately? Well, the answer would be, well, they didn't. So it's a genuine right. So if there are checks, i.e. for financial service institution, which will take place before someone can start, does this mean the substitute can't be put into that client's PSC's contract? No, as I said, it's HMRC have a problem with the length of time, and to a certain extent you can understand the logic, but in the vast majority of cases where substitution has taken place, the contractor knows well in advance they're going to need the use of a substitute. And ultimately, if it's taken place, we would always argue the right exists because it's happened. You can't deny something, say something didn't happen when it has. So if you can do the substitution quicker, great, but if you can't, ultimately you've still carried out the substitution and therefore the right still exists. Where does this sit with agencies in the supply chain? If a PSC individual was unable to complete a project in that instance, then it would be more common for the agency to source an alternative PSC rather than for one-man band PSC to source. Then if the original PSC engaged to carry out the contract needed 2 or 3 weeks away from the contract for whatever reason, and the agency sourced a substitute instead of the original limited company, then HMRC would say it's not a genuine right of substitution, because that's just simply replacing one contractor, one limited company with another. Presumably it's fine to use someone else, e.g. an agency, to help you find a suitably qualified substitute if you don't know one personally who is available in you. Providing that the selection of the substitute is the limited companies, and they then pay that substitute, then you would still have the argument that it's a genuine substitute. I mean, obviously, if the agency was sending someone in your place, such as with the question previously, then HMRC would say, no, it's not a genuine substitution. I think a copy of the slides will be sent out afterwards, but I'm sure that can be arranged if it isn't, but I'm sure it will be. Re your answer to the first question. Did you say that if any and only one of the three tests for employment are not met, i.e. move, substitution, control, then the contract is technically outside of IR35? Yes. If you are an employee, all three key status tests apply. Personal service, in other words, you can't send a substitute, you're controlled, or your employer has the right of control over you, and mutuality exists. In other words, an expectation on your part that you will accept work if it's offered, expectation from your employer that if they offer you work, you'll do it. So all three are present in a contract of employment. Therefore, for someone to be self-employed, only one of those key tests needs to be missing. So if, for example, your contractor could send a substitute, they can't be employed because their personal service isn't required. If a PSC has worked for a company for several years and never sent a substitute and doesn't have any obvious access to a substitute, the contract between the PSC and the company does have the substitution clause, and the PSC states further they could send a substitute, would HMRC accept the substitution, does apply and accept? Essentially, if the client said, if this limited company provided a worker of equal skill and ability as the contractor that we're using, we'd be happy with that, we would accept them as a substitute, then yes, it would be a genuine right of substitution. But it wouldn't be genuine if the engager said we wouldn't accept the substitute. So it doesn't matter what the contract says, and it doesn't matter what the contractor says. Sorry, it doesn't matter what the contract says, and it doesn't matter what the contractor says. If the client doesn't agree, HMRC would say then it's not a genuine right of substitution. Who will be classed as end client in a situation where a contractor from a limited company is engaged via a third-party organisation, not an agency, providing service to the client? Who will be classed as a client in the end situation where a contractor from a limited company is engaged via a third party? Right, okay. You're then talking about a managed service provision. So yeah, if it was a contract if it was a service provision contract, so for example, a business, and I suppose the most obvious one that most people think of would be IT. So if a business was providing IT services to a client, and the business that providing the IT services engaging contractors, if it's a genuine provision of services, then it's the IT company that would decide the status of the workers, not the client that they were providing the services to. If I substitute allocate my work to another member of the team who has already been approved by the client, do I need to tell the client when I enact the clause? Yeah, I mean, advice would be yes, because I don't know the circumstances of where the substitute will be working, but ultimately, yeah, I mean, I think purely health and safety reasons or whatever, then you'd want to let the client know that you were sending a substitute, and also you'd want written evidence of that. So should you ever be unfortunate enough to have a HMRC investigation, you could say, well, here, Mr. Inspector, here's the evidence of me sending the substitute and the client accepting it. From the session, my understanding is that PSC can have right substitution, however, the client can reject if the individual provider doesn't have the right skills and qualifications, so the PSC should be providing no appropriate skill and qualification. Yeah, I mean, essentially, as I touched on, again, it was a bit flippant, but it was, if you're an engineer, you couldn't send someone who's a painter and decorator. If for whatever reason you were providing your services as a IR35 tax specialist, you wouldn't send someone who knows nothing about IR35. So yeah, you have to send someone of equal skill and qualification or else no client's ever going to accept a substitute if the person who's they're replacing if they haven't got the same level of skills as that person, they're not going to accept them. Confirm there's no need for a contractor's company have a subcontract in place with the substitute's company as part of the supply chain. I'm not sure about it. Confirm there's no need for contractor's company have a subcontract in place. I mean, essentially, yeah, I mean, I might have got this question wrong, but essentially you don't have to have, if for a right of substitution to be genuine, you don't have to have, as the limited company contractor, someone in place ready to substitute. You know, you right at the start of the contract, you don't say, oh, by the way, I've got such and such who can substitute for me if needed. You don't need to have that there, and you don't need to have another employee in your company to provide the substitute. You can provide the substitute from anywhere, source it from anywhere, I should say. What if there's a standard firm-wide clause at the client agency level that does not allow substitutes, but at project level, the client representative approves payments would in reality accept a substitute? Ultimately, it's whoever the client is, whoever the engager is. If they say they won't accept a substitute, then the clause is invalid, and you then look at the other key status tests. If, for example, the limited company contractor cannot attend the particular assignment for a couple of days, it may well be agencies that send in a replacement substitute, as they do vetting on behalf of the end client. If this scenario happens and the replacement is paid by the original limited company, would this substitution clause be exercised legitimately? Now, HMRC would still argue it's not a genuine clause because the original limited company hasn't supplied the worker, even though the limited company is paying the worker. But yeah, I mean, it would be a very, very hard argument to have with HMRC. What if the limited company cannot find a suitable replacement? Then they would have to work that out with the end client. But ultimately, if the end client said, this contract needs to be serviced, we don't want any breaks in it, and you as a business couldn't send a limited someone substitute in your place, then presumably the end client would terminate the contract, which brings us back to one of the early questions where you then start arguing with HMRC about whether mutuality exists or not. If I was hiring a plumber and the main guy I had been dealing with wanted to put someone else in, I would want to ensure they were trustworthy and safe to be around my family, irrespective of their technical skills. I would want to write a veto. What is different to a business context? Well, essentially, as I said, you can only accept a substitute, or most businesses will accept a substitute providing they're suitably skilled and qualified. But it doesn't mean that there isn't some sort of vetting around contractors over and above that. But it's not. I mean, I would expect that if somebody came back and there was, I don't know, some criminal records check and whatever they saw they didn't like, they might then argue that they wouldn't accept the substitute. But ultimately, for a substitution clause to be valid, it should be you could only reject them because they're not skilled enough, basically, don't have the qualifications or skills. If HMRC decide to investigate, do they investigate the end client, the worker, or both? Under the current rules, which we're still in and we're still using, I'm talking about private sector rules until the 6th of April next year, if HMRC carry out an investigation, the first port of call is with the limited company and the limited company contractor. But during the investigation, they will ask the limited company contractor lots and lots of questions. And then they will then go to the end client and ask them very similar questions. And based on those answers, they will then make their status decision. Under the rules following from 6th April 2021, the investigation will change. It will start with the client, the hirer, and HMRC will ask them all the questions. And then once they've asked them the questions, they will then go to the contractor, limited company contractor, to basically ask them the same questions as well. Surely the key thing here that is important as getting substitution itself is actually documenting the evidence for later use if challenged by HMRC. Exactly. Whenever I do any form of training or speak to any clients, or all I simply say is documentary evidence is key. HMRC, whilst it might not be paperwork anymore, it might be held on computers, but HMRC will want evidence. HMRC always want you to prove something didn't happen. HMRC are just paper mad, if you like. They constantly want evidence. And I always say, if you have a contract that for whatever reason was terminated early, you keep evidence of that. If you have a contract where you, as a contractor, walked away because you got a better offer somewhere else, keep evidence of that. If you sent a substitute, keep evidence of that. Anything that you have that supports your arguments as to why you or this person is generally self-employed, you need to keep a record of. It doesn't matter where substitute is sourced from, could the agency provide a substitute? Now, as we touched on earlier, if the agency sends a substitute, HMRC would say it's not a genuine substitution. Some contractor provides services more than one client at a time. Is this sufficient protection? No, it's one of the early slides you saw where I did this, talk about 3 key status tests. Then there was some slightly grayed out tests underneath. They're called the lesser tests, but non-exclusivity is one of the lesser tests that you would use to support the argument as to why someone's outside IR35. Obviously, you always concentrate on the key status tests, but things about like financial risk, not being considered part and parcel of an organisation, non-exclusivity, they're arguments you would use to support why you believe someone is generally self-employed. Would the substitute provided by the limited company be covered by the company's employer liability insurance? Further this, would the limited company need to have employer's liability to be able to provide a substitute? Yeah, I mean, we always say that bear in mind that it's a limited company, it's a business. So therefore, as a business, it should have all the insurances you would expect a business to have, whether that's PI, PL, employers, because it's a business that's, that runs a risk of, being sued, runs a risk of not being paid. So all the problems businesses have that they insure themselves against, a limited company contract should do exactly the same. What happens in the situation where you have a contract in place with an operator with a PSC? They agree to a substitution clause, and then when it's time to do their determination, they advise that even though the contract allows substitution, they would not accept one, even if the equal skill, etc. Then you basically ignore that key status test and look at the next 2, control and mutuality. Because ultimately, if, as I said, if the contract isn't a genuine reflection of what happens on a day-to-day basis, then it doesn't matter what the substitution clause in the contract says. In the oil and gas industry, operators have been issuing blanket determinations inside IR35. Many have stated they would not allow for substitution, even though they've agreed to this when negotiating the contract. I do not consider this fair. Well, it's not for me to have an opinion on that. Essentially, as I said, ultimately, it's whatever the end client, whatever the engager, their decision is in respect of work is entirely up to them on whether I agree with it or not. Does right of substitution apply if the limited contractor doesn't provide the substitute? For instance, if we knew someone else who would substitute the PSC, but not actually via them? No, I mean, essentially, the limited company contractor has to supply the substitute, and they have to pay the substitute as well. Will you be holding any seminars on the other 2 key factor tests? I'm sure that's something that we can do. If a bank provides a log-on ID specific to the contractor rather than the individual, then the substitute using the log-on ID would overcome the onboarding issue. The abuse of log-on ID by any individual as a contractor could make the contractor responsible for the abuse. Yeah, I mean, ultimately, how a substitution is applied and dealt with by the client, it would be entirely up to them. If they were happy with some sort of arrangement like that, then it's their choice ultimately. I had a direct contract with my client a few years ago, which included a substitution clause which was never used. In my HMRC IR35 investigation, the comment from the officer was that, well, would your client have really accepted it? Surely it's not something that they have a right to ask or expect me to answer on behalf of my client. HMRC have a tendency to ask whatever they like. And I know this because I've dealt with lots of investigations from whilst I've worked for Qdos and in previous employment, but also from my time as a HMRC inspector myself. But ultimately, you don't have to answer their questions if you don't think it's relevant. And our advice whenever we do represent clients, and whenever I represent clients, is ultimately don't meet with HMRC, get them to ask their questions in writing where you've got some control over of how you respond. But yes, you're right. They can ask questions that they deem fit, but whether you choose to answer them or not is entirely up to yourself. Okay, I've got one more question that I need to answer, as this one was asked a while ago and I haven't got around to it yet. And then I'll need to bring the session to a close. But obviously we'll send the recording of this session, and then if anyone else wants, if you want to join me, and I'll be doing one on overseas, how overseas clients, etc., affects IR35 under the off payroll rules coming in 2021. But here's the final question I've got to answer: is there a time limit on using a substitute? As an example, I had the need to use a direct substitution a few times. The last time was about 9-10 years ago under the same contract and employers consortium house builders I'm still working on. Is this too long ago to use an example of substitution of IR35 purposes? HMRC, I can guarantee, would say yes, because I just know HMRC, but hypothetically, the terms and conditions of your contracts were the same and they were with the same engager, then clearly that engager has no issue with substitution. So if you said to them, would you accept a substitute now, equal skill qualification if I sent one now, and their answer was yes, then you've got the right to substitution. And the fact that substitution has taken place supports that you have got the genuine right of substitution. So if you're unfortunate enough to have a HMRC investigation and you had Qdos representing you, we would be making a strong argument that the right of substitution is genuine and exists. So thank you all for taking the time out to listen, and thank you all for the questions. I'm sorry I didn't get around to all of them, but hopefully some of the answers I gave to early questions answered any of the questions I didn't actually get around to dealing with. And like I said, if any of you want to, I hope you'll join me today on the session at 2 o'clock about overseas. Thank you very much.